My name is Dr. Faith Mashele. I am the chairperson of the CIPS Gauteng Branch. I would like to get right into it and talk about how it has been business unusual since the Constitutional Court handed over the judgment around the Preferential Procurement Regulations of 2017, where we were advised that the regulations are inconsistent and were declared invalid. We have seen a lot of mixed emotions, mixed reactions around this, because this judgment ordinarily also included delays in public service. We even saw a case where tenders had to be stopped while the National Treasury was working the PR and also trying to avert the situation. We have also seen the draft Preferential Procurement Regulations of 2022 being issued for public comment. Whether this is the solution that we were hoping for, that remains to be seen. We've also seen organizations such as Transnet, for instance, who have applied for exemptions, and we've seen the National Treasury expedite these in a very impressive manner, I suppose. But then again, many questions remain around this. And then I think what I want to also pop into your minds this afternoon is whether the question around the public procurement bill, whether this is the silver bullet that we're all hoping for, and whether it will help us to rewrite what we're seeing now. It remains to be seen. And I think with that, there is a quote from Oscar Wilde that said that the one duty that we owe to history is to rewrite it. I want to introduce the panel of esteemed experts who are going to answer all the questions that you might have. I'm going to start with advocate. The advocate is an admitted advocate of the High Court. He is an MSIPS member and currently is the head of department for the Center of Excellence at the State Information Technology Agency. And our advocate has got strong experience in the field of procurement, compliance, governance, and risk in the SOE space. So I'm really hoping to hear the advocate's views around this matter today. The next panel that we have is a familiar face and a name that we all know, Mr. Kamogelo Mampane, FCIPS. He's the Executive Chairman of Supply Chain Council, South Africa. He is the CEO and founding director of TK Global Expert. He's the former chairperson of the State-Owned Procurement Entities Forum, the SOOF. He's worked with the National Treasury. He's probably also known some of the things that we might not know. So we're waiting to also hear that what he is privy to, as he's worked for organizations such as SARS, Anglo, Transnet, and Eskom. The next panel member that I'd like to introduce is Dr. Dolly Makole. Dr. Dolly is my colleague who currently serves in the CIPS Gauteng Branch. She is an MSIPS member, and she's also a lecturer in PFMA, the MFMA with the University of Pretoria Enterprises. She's got a PhD in business administration and a postgraduate qualification in supply chain management. And she also has more than 20 years experience in supply chain management. So I am very quite confident that our panel will be able to assist us with this conversation as we look at how will this, the impact of the judgment, how will that, what impact will the judgment have on business operations? We'll look at what are the short-term perhaps and long-term remedial actions that can bridge the gap in this judgment, and also what are some of the legal implications. Ladies and gentlemen, with that said, I would like to open the floor.
I am Advocate Thulani Mtshwene. I am the head of department responsible for the Center of Excellence at the State Information Technology Agency. With regards to the triple PFA and the invalidation of the regulations thereof, I'd first want to take us through the provision which enabled the coming into effect of the triple PFA as an act. Now, the requirement comes from section 217.2 as well as 217.3 of the Constitution. Now, the Constitution under section 217.2 says that there's nothing which stops organs of state for putting in place policies which serves to promote the advancement of certain categories of persons, as well as promoting the reconstruction and development program as one of the measures aimed at ensuring transformation, localization, and so on. Now, in terms of Section 217.2, it makes reference to organs of state having to put in place the policies which serves to advance specific goals, categories of persons, as well as RDP. Now, National Treasury, in terms of Section 217.3 of the Constitution, is then merely meant to put in place a framework within which organs of state are then meant to promote the object of Section 217.2, as well as Section 217.3, as well as the Act itself, which was enabled, which is the PPPFA. So they are not meant to then preclude or to prevent organs of state from being able to exercise that particular discretion. They are merely meant to give guidance to organs of state. Now, that is what primarily had led to the invalidation of the regulations. Now, what the Constitutional Court, together with the Supreme Court of Appeal, found was that the framework that National Treasury has put in place seems to have been beyond the powers of National Treasury. And that is that it is too restrictive, and organs of state are unable to then be able to promote that which they're expected to promote through specific goals, as well as RTP. Now, the funny thing it is that in terms of the PPPFA, if you look at Section 2.1, it refers to 80-20 and 90-10. Now, the 80, as all of us are quite aware, relates to the maximum points one can be allocated insofar as price is concerned, and the 90 refers to the maximum amount of points which one can be allocated insofar as price is concerned. Now, this then leaves us with 20 and 10 for the advancement of preference. Now, one of the funny things which had transpired at the time when the regulations were issued, it is that the 10 and the 20 were only reserved for the allocation of points insofar as one's BBBE contributor status is concerned, but not necessarily what the Constitution required, as well as the Act itself required, because the Act said the 10 and the 20 are for the advancement of specific goals or the RTP-related goals, not necessarily confined to the allocation of points on BEE. And that's what the Constitution itself says. It says it is for the advancement of specific goals, the advancement of historically disadvantaged, and the advancement of RTP. But the regulations only confined it to the allocation of BEE points, to the exclusion of that which the Constitution as well as the PPPFA had stated. Now, that's what then the Constitutional Court had said. Now, further to that, the Constitutional Court had then invalidated the rest of the regulations, and not necessarily what the Agribusiness had disputed. Agribusiness disputed Regulation 3B, which refers to the stipulation of pre-qualification criteria. They challenged Regulation 4, which was the pre-qualification criteria. They challenged Regulation 9, which was the subcontracting requirement. But the funny thing that the Constitutional Court did, they then invalidated the whole regulation and said that the regulation 3B, 4, and 9 must not be read in isolation because they are also linked to the rest of the regulations. Hence, the whole regulations were invalidated. And lastly, on this slide, the Constitutional Court, as all of us are quite aware, never gave guidance in terms of what do we then do after the invalidation of the PPPFA regulations on the 16th of February 2022. There are two possibilities. It is either the 12-month period within which the order is suspended can come into effect, or the regulations are out, and therefore we as organs of state, as a stopgap measure, would need to then apply for exemption from National Treasury and thereafter develop our own policies in an effort to then be able to continue to procure. But we are still awaiting clarity from the Constitutional Court, because National Treasury, I have been reliably informed that it has approached the Constitutional Court already to seek clarity whether the 12-month period must then calculate from the 16th of Feb, or if the 12-month period can then be said to have expired because it was pronounced on by the Supreme Court of Appeal. And if it ran from the time that the Supreme Court of Appeal had pronounced on the judgment, it then would have meant that that 12-month period would have expired in November, around the 11th of November last year. But we are waiting now for the Constitutional Court to provide clarity, from which then we'll be able to have certainty in terms of what then becomes the way forward. But in the absence of that clarity, I then implore our colleagues from various organs of state to seek exemption from the triple PFA and thereafter draft their own preferential procurement policies to then enable them to procure using those particular policies so that then business operations are not stopped. I did touch on this particular slide insofar as which regulations were challenged by Agribusiness, but as we all know now, the Constitutional Court then took a decision to invalidate the whole regulations as opposed to the only three which were challenged by Agribusiness, which was Regulation 3B, Regulation 4, and in the next slide, you then see Regulation 9 on the compulsory subcontracting, where the estimated contract value is expected to be in excess of 30 million, then 30% of that, if feasible, had to then be subcontracted. So that was also one of the regulations that were challenged, and mainly because the subcontracting element was only confined to what was defined as the designated group. That's what the Agribusiness had a problem with, because this seems to have been an act of ultra vires by the minister. On the 25th of February, as well as on the 3rd of March, National Treasury issued two guidelines. Now, these are guidelines and do not, the compliance thereof is not peremptory. We do not have an obligation to adhere to the provisions of these guidelines. Why? Because they have not been issued in terms of Section 76.4. You would note that only instruction notes issued in terms of Section 76.4 by National Treasury in terms of the Public Finance Management Act have legal status to an extent that they're not in conflict with the Treasury regulations as well as the PFMA itself. Now, in this instance, on the 25th of February and the 3rd of March, National Treasury did not issue an instruction note, but it issued guidelines, which then meant that it is at the discretion of various organs of state to either adhere to those guidelines or to ignore them. Now, the guideline given by National Treasury was that any transaction that was issued before the 16th of February, before the Constitutional Court pronounced on the validity of the regulations, the organs of state can continue to then finalize. And the reason it is that in law, every judgment, every regulation, every instruction note, every act does not have retrospective effect. What that means is it does not then regulate previous actions unless it states on that particular legislative prescript. But what typically happens is it then has prospective effect. It only regulates that which occurs after it has come into effect. Now, here, if we as organs of state have issued a tender prior to the 16th of February, we can then finalize it and make use of the triple PFA regulations 2017. But if we issued it from the 16th of February, the best thing it is that we then put it in abeyance as advised by the guidelines issued by National Treasury, because we are not certain how to evaluate the bids that would have been received. Because from the 16th of February, there were no regulations. What that then meant was whatever would have stated as the preference point system in our tender document can be challenged and would be invalid, so to speak, until such time that we get advice from National Treasury after the Constitutional Court has given the clarity. Now, anything issued after the 16th of Feb, then also we were advised by National Treasury not to proceed with finalizing those particular transactions. Why? Because, as I've mentioned, there's a gap insofar as which then will become your award strategy insofar as the preferential point system is concerned. as the regulations have been invalidated. I will later on give a view in terms of what I propose then be the way forward. Now, colleagues, for you to then be able to proceed with issuing tenders, you would need, as I mentioned earlier, get exemption from the National Treasury from having to apply the PPPFA itself as an act. Now, the reason it is because the act itself is quite silent in terms of, number one, when to use 80-20 or 90-10. Because the act, insofar as the provision, section 2.1 is concerned, it says there would then be regulations which would set out the value thresholds to be used to determine whether to use 80-20 or 90-10. So the act itself is quite silent. Hence, then you cannot then revert back or default to the act in an absence of the regulations, because the act has certain restrictions. The important thing that you would need to do, you would need to seek exemption from the act so that you can then develop your own preferential procurement policy, which you can then use to procure in an absence of the having to apply the act and the regulations. And through you, Dr. Mashele, I'm also quite willing to share the draft policy that I prepared for the State Information Technology Agency, which we then intend to take through our various approval structures, which we are then going to rely on after we have been granted an exemption by National Treasury from having to apply the Preferential Procurement Policy Framework. Firstly, my view it is that if the Constitutional Court comes and says the 12-month period expired last year because it had to be calculated from the date on which the Supreme Court of Appeal had pronounced on this issue, it would then mean that any tender issued from the 16th of Feb must then be cancelled. But if the Constitutional Court comes and says the 12-month period can then be calculated from the 16th of February, which is the date on which the Constitutional Court had then pronounced on this issue, then those tenders issued from the 16th of February can then be evaluated and finalized in terms of the 2017 regulations, because then the order of invalidity would have been suspended for 12 months from the 16th of February until next year on the 15th of February 2023. Lastly, now moving on to the draft regulations which have been issued by National Treasury, I just wanted to make 5 key points insofar as the salient factors of that new draft regulations is concerned. And I hope that a number of our colleagues gave comments because the comments were due on Monday, which was the 11th of April. Now, the 5 key things from those new regulations. Now, the first one, it is that we are now free as organs of state, if the regulations are passed as they currently read, to then make use of the 10 or the 20 points to advance specific goals and the measures stated in the Gazette for the Reconstruction and Development Program. And the points have now not been confined solely for the allocation of BE points, which was a flaw because, as I mentioned in my opening remarks, those 10 and 20 points in terms of the PPPFA under Section 2.1, as well as 217.2 of the Constitution, were not meant to solely be confined for BE related points, but they were meant to be allocated based on specific goals or RTP measures, whichever the organ of state would have determined on a case-by-case basis. Now, I welcome personally that the points in terms of the draft regulations have now not been confined solely to the allocation of points based on a BE contributor status level. Lastly, there's no local content, and this is understandable, but in terms of how the current regulations read, we can still be able to factor in local content as a specific goal or as part of RTP. But as the PPPFS and Act says, we must then be able to measure how we are going to allocate points, and it would be a point-based evaluation. Now, lastly, there's a mention of income generating transactions, which I believe is ultra vires. Now, I think the National Treasury is acting beyond its powers because those regulations are meant to regulate instances where we procure, hence they are procurement regulations. They are not meant for income generation. you know. So I think there it is quite odd that they included income generation, as that is not cannot be defined as procurement. It is merely defined as where revenue needs to be generated.
I think, Advocate, I'm not going to repeat what you said, but we need to remind ourselves where we are. And the reason why, Advocate and everyone on the panel, is that lest we forget where we come from and who we are and where we are going. This year, many people were quite surprised to hear that South Africa is the most unequal society. But my good doctor, you will know that I've always been saying this probably from the first day we met. It's not a new thing. South Africa in 2015, right? South Africa already at that time was already the most unequal society. So it is not true that it is only now that we wake up and realize that South Africa is the most unequal society. It is not sustainable for the majority of people in any country to be sitting outside the mainstream economy. It is not sustainable. What we have seen in KZN, in Gauteng, it's going to be an overnight movie. If these things, and especially our state organs that are mandated to be at the forefront of development, are going to ignore the issues that are bubbling, no more on underground, but they are now on the ground with all the movements that we are seeing in the country. So it is very progressive to hear what the State Information Agency is saying about being at least at the forefront and taking the lead on how things should be done. But it's very sad to see some of the state organs in this country that are saying that, because of not even David and Goliath, but because of the two bulls that were fighting in the Constitutional Court, that they are afraid to get into that space. It requires leadership, and as I said, we are glad to see that leadership is coming. That was in 2015. 2018, the numbers stays exactly the same. South Africa, once again, it's the most unequal society. What can we do? So the discussions today, if you look at the countries which the inequality gap is very low that we constantly benchmark with. For example, the countries like Netherlands is an example. If you look at their expenditure as a proportion of GDP on procurement goods, it is quite high, but you hear a lot of things coming from government or from many institutions say, no, we need to trim the budget. If you are saying you want to compare yourself with Netherlands, South Africa is only spending about 8.6% of procurement of the GDP on procurement of goods and services. And if Sweden is a benchmark, if Netherlands is a benchmark, then we should do better. So this 1 trillion of procurement spend that is currently being mismanaged, whilst yes, we can talk about fraud and corruption, but our legal framework, if it's not going to focus on making sure that we are able to bring the people that are outside the mainstream economy, put them in the mainstream, focus on them, and make sure that preference is given to them. Unfortunately, and I'm sure SITA is way ahead of many others in this, but we are still going to perpetuate the inequalities that are there in the country. Because it is supply chain professionals that are here today, Chairperson, that made South Africa what it is today. I will repeat that. The procurement professionals in the country made South Africa what it is today. If South Africa is the most unequal society today, we have contributed to that. We made it like that. The companies that are listed in the JSE, the bulk of them have contracts with government, and the bulk of them went through a procurement system. And they were awarded contracts through this legislative framework. So if 22% of expenditure emanates from government, especially the procurement of goods and services, I am scared, to say the least. Now, just in summary, my advocate, I'm not going to rewrite or at least talk more about the things that you spoke, but because the Constitutional Court, the majority judgment was a judgment against the minority. Do you agree with me, advocate? I'll repeat that.
I do agree with you.
You agree, thank you. The majority judgment was actually a judgment against the minority judgment, and they almost forgot that there was a question on the table. So that is why our learned advocate is saying that the majority judgment, unfortunately, failed to deal with the matters at hand, right? There were questions that were asked. SCA made a decision. They almost ignored what SCA did and gave a different ruling, completely different from what the SCA was saying. But advocate, this is for me the biggest problem. The majority judgment said, because if you read triple PFA, it uses this word necessary and expedient, right? That the minister may put a legislative framework to govern how contracts should be awarded. But our majority judgment advocate said that the minister, okay, let me read it as it is. It says the minister has, the last paragraph. Let me see if I can show you with my mouse. And for us as professionals, we really need to consider this. They said that the minister has no business in creating a system of preference. And then they continue to say the power lies elsewhere. So if this is not reversed, if this is going to be taken as the final judgment, why is the minister still trying, even in the new regulation, trying to set some preference or some system of preference? If the Constitutional Court said, Minister, you do not have any business in doing that, why should advocate go and ask you see, advocate, now you are going to a place where they are saying the powers do not lie, because the judgment says the minister does not have those powers. So why are we going to a place where there are no powers and we say, give us the powers to deviate? You might as well, you don't need a deviation, but we understand that it's for political reasons why state organs are going to National Treasury to ask, but those deviations, they do not have a legal standing. Advocate, I'll repeat, your deviation requests do not have any legal standing, except if those deviations, you are deviating from the act, but you cannot deviate from you cannot ask the minister to give you something that he doesn't have the powers to give. That's the first thing. So even in the current regulation, secondly, the minister and the Constitutional Court said that the powers lies with you, advocate, isn't it? It said they lie with the state organs. Is that not true? So the system of preference where Constitutional 2172 says that there must be a legal framework, those powers, and if you look at subsection 3, it says that a legislative framework, right, must be implemented by the organ of state. Now, the Constitutional Court read this to say that the state organs, the powers lies with the state organs, not with the minister. So I'm really looking forward to be seeing this discussion unfolding in our country, and where especially the state organs are going beyond the 90-10 and the 80-20 principles, because as our learned judges said, and whether we like it or not, and I haven't said any views, my views. I haven't spoken about my views. I'm now telling you what the Constitutional Court said. It said that the minister has no business in creating a system of preference. Finish and clap. Because the minority judge was saying that because the acts say that for necessary and expedient reason, the minister may, and the majority judgment said, let's help you because you did not explain what is this word necessary or expedient. So, but even with that, those powers do not lie with the minister. Now, when I wrap up, I want to ask this question to our colleagues. The powers to define this word that is called preference or categories of persons, the powers to define disadvantage and unfair discrimination should not lie with National Treasury. My advocate, the definitions of categories of preference, the definitions of black, the definition of SMME, the definition should, in my understanding, should not lie with National Treasury.
Yeah, I agree with you, Dem, because if you refer to Section 217(2), it is quite specific that it is the organs of state whose policies are then to define the categories of preference, as well as the entities that are to benefit from such specific goals and RDP. The Constitution is quite clear.
Absolutely. So that's the first thing. And so whatever regulatory framework that National Treasury will come up with, unfortunately, it will still fail the master if it defines preference. And that's what they need to be very careful of. So the broad-based Black Economic Empowerment 2003, and this is something where, and perhaps because we understand that those that are employed by the state, they are not going to take the state to court. But there's two legal frameworks. Yes, there are many other legal institutions, the legal instrument in the country that almost contradict one another. However, we have accepted that the Broad-Based Black Economic Empowerment Act is the one that defines this thing that is called black, this thing that is called, of course, SMME is also defined elsewhere, but that is also discusses the categories of preference. So as I end here, the definitions sits within Broad Black Based Economic Empowerment Act. The definitions of categories of preference are clearly defined. And what is very good with this legal framework, by the way, the codes of good practice also say, advocate, that if there is any other law that is going to be contrary to the BEE, the Broad-Based Black Economic Empowerment and the Code of Good Practice trumps any other law. So in other words, in as far as the definitions of preference, we do have a very solid law that has been taken to the courts for many, many years, and we do not have a confusion of what is categories of preference. If you also define, let me say, and by saying, so procurement people will always say, all right, now in terms of awarding of contracts, if you issue, for an example, a tender for banks, what are the laws that they are going to use? You don't have to scratch your head. The Financial Sector Charter has already set targets. So if 30% of contract must go to Black women, then your contract must reflect that sector charter that you are issuing the tender for, or in that particular sector charter, whether it's tourism, construction. By the way, CIDB has a very clear definition. Those that are doing infrastructure programs, but do not even think about applying triple PFA, because the construction codes and the CIDB gives you a very clear directive on how you must empower people that are still unfairly disadvantaged because of our law. So I've just put all of those laws there, that it doesn't matter. We have enough regulations. We have enough laws. We have enough guide to guide our supply chain professionals, to guide even government to say what is its preference and how it must be dealt with. And the definitions are clearly defined in the codes of good practice.
How do we then pull everything together? But I love the transformation lens. Dr. Makole, we've heard about the legal confines where Advocate Mtshwene painted a picture of how do we walk within the confines of the law. We've just had a brilliant presentation around the transformation lens. And I know that you were going to talk and you had prepared something about the remedial actions around what can be done.
Before I go into the short-term or long-term remedial actions in bridging the gap on the Preferential Procurement Regulation in line with the judgment, I just want to bring in something necessary that we have an understanding of. I'm glad that we have advocate here who can also assist us in terms of our different understanding of use. Based on what the advocate touched on, so I'm building up from the previous speakers in line with their subject. Based on the court ruling, my views or my understanding in interpretation of both the courts, the Supreme Court, as well as the Constitutional Court, is that the Constitutional Court did not necessarily make a ruling. They rejected or they dismissed the appeal, meaning that the Supreme Court judgment remains. So we need to have the synergy or the alignment in terms of what both the courts have done in terms of the ruling. As much as that has been said, especially on the Constitutional Court, the transitional period or the suspension of the invalidity of the regulations, which was 12 months. That is one thing as well that we need to have a look at and understand while awaiting the clarity in terms of implementation. So without wasting time, I just wanted to highlight that as we know that all public entities are now supposed to each come up with our own preference without the benefit of detailed regulations. On the other hand, the light of the State Captures Commission findings of insufficient competence and capacity, this may be difficult to achieve. As much as we have seen National Treasury currently trying to remedy the situation by urgently having a look at a new regulation addressing as well the Supreme Court of Appeals judgment in line with the PPPFA Act. Many people in the public procurement may not also have studied the preferential procurement in much detail, and now we then expected to put policies together to enable the act. This may be difficult to achieve, as well as majority of the public sector officials, particularly in the SM environment, are not necessarily familiar with the prescript, not to mention the application or the implementation. And I'm speaking from experience because I'm on the ground, I'm in that environment. I know that many people are not aligned or do not understand the implementation or application of the law or regulations within supply chain. So suggested recommendations I've highlighted 5, which are aligned to what the advisory note from National Treasury has provided. However, we also need to bear in mind the Supreme Court of Appeals ruling in terms of accountability and what the organ of the state have powers upon, as alluded by my colleagues earlier on. So these 5 are not necessarily mutually exclusive, but need to be carefully considered in the context of its own merit and also looking at the risks that the entities might be exposed to. The first recommendation would be to comply with the Supreme Court or the Constitutional Court compliance in terms of modifying our policies, and as well as SOPs and templates that we have. This might be a quick win, provided that entities knows exactly what they want in terms of the preference targets and objectives. And that, given the ruling, might be one of our long-term remedial action if we put in place our policies, procedures to align with what the Act expects of the entities. Number 2, we may continue and assume that there is a suspension period and the Triple P regulation of 2017 remain, although this being dangerous move in the absence of such clarification. The need to fast track the clarification by National Treasury is then of crucial importance to avoid disastrous situation of potential irregularities, which might even backdate from November 2021 in line with the initial court ruling. So if the clarity is not sought and probably Constitutional Court comes back and say, no, the suspension still remain as per the Supreme Court, it might mean that the 12 months has already lapsed in November 2021. The only possibility fallback that we have is the fact that the mere fact that the Constitutional Court entertained the appeal by National Treasury, that might provide us some relief that the suspension period then would be delayed to the date of the Constitutional Court ruling, which is then February 2022. That as well, it's probably our short term while we navigate our ways up in terms of how to put in place long-term solutions for our entities. Number 3, it's to consider the deviation process, continue with priority tenders and quotations as deviations in line with Treasury Regulation 16A, as well as MFMA 36, 1A5. Deviation, again, there we're talking about the deviation from the process of competitive bidding, application of your triple PFA in the process. Then number 4 would be the consideration of the application of exemption from the PFMA as alluded by advocate. So one thing we need to understand here in terms of the exemption and deviation are 2 different processes. Exemption deals with the Act in a sense that we would be exempted from being compliant to the triple PFA. Therefore, we would then internally be able to decide on our own objectives and targets, but that is short term in a sense that we still have to address the element of updating our policies and procedures, as well as determining our goals for preference points as per the Act. This also I've indicated that it is a short-term solution. I must say that the advisory note of the National Treasury came at the wrong time of the year and for many institutions, which means that it is difficult as well to place projects at abeyance as recommended. As alluded by my colleagues, again, this is an advice, and National Treasury has put emphasis on their position and disowning whatever decisions that entities may take when it comes to putting on hold or continuing. Hence, they emphasized on the notice, advisory notice issued on the 3rd of March, emphasized the contents of the one of the 25th of February. The last one would be to take Treasury's instruction, or not necessarily instruction, advisory, to freeze all transactions since 10 o'clock on the 16th of February, meaning that we are reacting to the National Treasury advisory. This for me would be the last resort, since the advisory note of Treasury and its emphasis, as I've mentioned, support actually the court decision on the responsibility and accountability on the accounting authority and officers relating to making decisions on how to apply the PPPFA Act provisions in the organizational SCM policies on preference point matters. The impact with this would be at the detriment of service delivery, and something that we need to avoid given the different mandates of multiple entities. Therefore, it's again a sole responsibility of each public entity on how to proceed. Those are just recommendations that I've highlighted.
Then Malika says, thanks advocate for the insightful presentation. I've noticed that the Western Cape is still advertising bids and tenders. It is purported that they did seek exemption from National Treasury, so they sought exemption, but the National Treasury denied them with the reason that they can't approach requests on a piecemeal basis. They're still applying the subcontracting in line with CIPS Act, the SFU, and concomitant contracts. Can't all organs of state learn from the Western Cape?
I'm not sure if you have had sight of the letter of exemption from National Treasury, but what it does is there's a line, which I assume is a generic line or on that particular template, which says that okay, you are exempted on the specific things that you had sought exemption for. But I think it is just a generic one, because we as SITA had made a general request for exemption. It was not per particular procurement event. So we just said, whatever we now intend to issue, can you just issue it? You know, we did not then say for these particular categories of acquisition or demand or whatever the case may be. Now, and I think maybe that is why the National Treasury, in its response to the Western Cape, it then said, we don't want to exempt you on a case-by-case basis. Rather, probably like SITA, come and say to us, exempt us from the period where clarity has not been sought until such time that clarity is sought from the Constitutional Court, or until the new regulations come into place, whichever comes first. You know, probably that is the case. And at the time when the judgment was delivered, around the 16th of February, I think a day or so later, I saw a draft regulations that were published for public comments by the Western Cape government. I'm not sure if any of our colleagues also had sight of that. So I'm guessing probably they may be making use of such regulations in order to then procure. But if an organ of state has a policy which makes provision for local content in whatever form, makes provision for subcontracting and so on, you can still do it. It is only invalidated insofar as where you use it in terms of the regulations, the PPPFA regulations, but not in terms of where you then have it as part of your own policy Why? Because Section 217.2 of the Constitution says your policy as organs of state can make provision for whatever categories of preference you want, or for whatever specific goals you want, and also to advance RTP if you feel that there are opportunities to do so. But just as a last comment on this response, I saw the draft Western Cape regulations after, shortly after the PPPFA regulations had been invalidated. So I'm guessing probably they may be procuring through what they themselves have put in place as the Western Cape.
Tandy Pink says, Western Cape also issued a circular whereby they decided to continue with the regulations until clarity is provided by the Concord. Ooh, okay. Advocate, can they do that? But I think if looking at this, I think it's also interesting to see how other organizations are becoming deliberate, because I think at some point there must be decisions that are taken to say, especially if you're talking, and if you listen to that presentation around, I think if you mix the first presentation from advocates and mix it with what Mr. Mampane said, that transformation lens, we're going to need to take deliberate decisions and perhaps unpopular ones. But I want to hear from Advocate Mtshwene, is this the right thing to do?
Yeah, and I think I'd borrow from one of the messages, or I'm not sure what we call it here on Zoom, but which says that if you put 10 lawyers in the same room, you'd have 10 different opinions at times, you know. I know that with ESCOM as well, they then said, no, look, in terms of their own legal interpretation, the 12-month suspension should be calculated from the 16th of February, and therefore they are continuing as though the 2017 regulations, the order thereof is suspended for the next 12 months from the 16th of April. Now, the same happened with the Western Cape government, but they also then issued draft regulations, which mirrored almost that which was contained in the 2017 regulations. But insofar as what happened to those, as I've mentioned earlier, I'm not aware. But it is quite possible that they also labor under an impression that the order of invalidity has been suspended for 12 months. Now, whilst that as well can find some justification from a legal perspective, but it is a bit risky in my view, in that as much as the Constitutional Court had agreed with the Supreme Court of Appeal, the Constitutional Court also went further and beyond by invalidating the whole regulations as opposed to the 3, which the Supreme Court of Appeal only invalidated. Now, if the Constitutional Court comes and says the 12 months has expired, it will then render whatever transaction that would have finalized post 16 February as irregular, you know. Hence, then I'd say the easiest one would be to seek exemption and then continue. Even if you continue in terms of the regulations, it's up to you, you know, because then you are at liberty and have the discretion to state in your own preferential procurement policy whatever you deem fit as what are relevant measures that will enable you to advance the specific goals you have identified, measures insofar as RTP is concerned, promoting the categories of persons. That for me, seeking an exemption would be an easier one. Now I take Kamogelo's point that the requesting exemption from National Treasury may be construed then to be that we are giving National Treasury powers which it does not have. I do not agree with that, simply because if you look at Section 217.3 of the Constitution, it says a framework will be developed through national legislation. If you read the PPPFA, it says, I am that framework, because it says it aims to give effect to Section 217.3 of the Constitution by providing a framework for the implementation of the procurement policy contemplated in Section 217.2 of the Constitution, and to provide for matters connected therewith. So whether we like it or not, it is the framework which has been given to us, and such a framework, and I accept that the framework does not go as far as all of us want to. You know, my own personal view, it is that we are trying to fix the faults that are contained in the PPPFA through the regulations, which is wrong. My own personal view is that the PPPFA as a framework needs to be scrapped altogether, and a new legislative framework put in place which would enable organs of state to be to advance further that which they are charged to advance through Section 217.2 of the Constitution. That's my own personal view, But unfortunately, we are still sitting with a piece of legislation that has been enacted in terms of 217.3, and therefore, whether we like it or not, we then need to adhere to the prescripts thereof.
And I saw Kamogelo just nodding his head with the last statement, because I think that I had thought that is why we were going to have the procurement bill, wasn't it? To make sure that we don't have these misalignments, we can look at one piece of legislation and be able to say this is the guideline that then overrides and then is able to give us that guidance. So you're saying that, okay, go ahead.
Yeah, no, I agree with you. That's exactly what I'm saying. To say, no, look, the triple PFA, as it currently reads, does not really do much insofar as responding to what the Constitution requires. That's the first. And secondly, there needs to be a legislative replacement of the triple PFA. Whether it becomes the procurement bill or not, that's something else. However, whatever it is, in my view, should then afford more powers to organs of state, for organs of state to then be able to advance whatever specific goals are concerned. Now, I accept that some people, when you talk of the triple PFA being more cost-centered than it being more transformation-driven, they will then say to you, but you are required to derive value for money. Now, if I develop a black-owned entity, a small entity, whatever cost I pay, if that as well may be construed to become value for money, because value for money does not necessarily speak of the cost. It also speaks of the overall value you derive from a particular contract you have put in place. And further to that, we accept that if you look at section 195(1)(b) of the Constitution, it then says to us, the resources must be used effectively, efficiently, and so on. So when we then talk of the triple PFA or whatever legislation is to be drafted to advance, not having to focus on cost only, we are saying that with due regard that whatever outcome for procurement process is going to be would also ensure value for money as required from all of us as organs of state in terms of section 195(1)(b) of the Constitution. We're not going to be reckless in how we are to advance transformation and so on. We are not going to be reckless.
Tebogo Moromane, committee member for the CIPS Gauteng Branch. I just want to, maybe it's a comment and hello, advocate. It's a comment and a question. The reason why most of the organizations or state-owned entities sought exemption from National Treasury, even though we knew that the National Treasury did not have any mandate to issue those exemptions, was the issue of the AGSA. Because I think Dr. Makole has indicated that, much as these regulations have been around for however many years, most of us do not know them from page to page. We always resort to Advocate Thulani to, interpret those for us. And the issue also that, we have sought those exemptions that we thought that, but if the minister does not have any mandate to have done that, why then sought the exemption from National Treasury? It's because AG, when they come, especially we know that they bring students that have not been, through to the audit of the state-owned entities, you will end up with material findings in terms of this regulations if we went on just to publish tenders without getting permission from National Treasury to say we can, we are exempted, that we can continue with the tenders that we have. I think that's what I had to offer to the conversation.
Thanks for your contribution. We have So your contribution was essentially around the compliance, which was the first point I think that Dr. Makole touched on, to say we would have to comply, because if we don't, it's going to come back to us either through the AG or still as an issue of non-compliance.
Come from KZN Treasury, responsible for transversal policies in supply chain. So what I wanted to check, in one of your speakers that was on the I think from SITA, is indicated that there is an allowance to put in your policies subcontracting and pre-qualifying criteria to empower or to enforce or to enhance the provisions of section 2173 and 2. I just wanted to get some clarity maybe from your panel and maybe from the same speaker, that's how far does the implications of the Supreme Court judgment go, and so far as it's pronouncing direct to the invalidity of those sections, that the minister was not empowered by way of regulations to seem to be extending the shape of the Framework Act, or so that means the Supreme Court, if I read it correctly, that judgment is saying the regulations as they are unlawful, not that they were issued by the wrong hands, like the Constitutional Court. And the Constitutional Court now is not touching on those regulations. So how far the implications are, is it not now going to be a case where we seek to extend the provisions of the Act by way of policies?
Now, I'll start off with Section 2.1 of the Act. Now, Section 2.1 of the Act says 90 points are reserved for price, 80 points are reserved for price. Now, for us to then drive the object of the Act, which is the triple PFA, as well as Section 217.2, in that we need to promote specific categories, as well as RTP, we can only do so within the 10 on the 20. That's what the Act says as it currently reads. If you look further in the Act, it then says to you, whatever specific goal you then have identified, you must be able to allocate points in order to determine who scores what within the 10 and within the 20, right? Now, when you then look at the regulations which were promulgated, you then had Regulation 4, which spoke of pre-qualification. So no points were then to be allocated. It was a yes or a no. But the Triple PFS and Act said points must be allocated. And when you look at that pre-qualification criteria, it's not fit in within the 10 or the 20, it's a standalone. Whilst the Act itself, when providing a framework, it speaks of a framework which includes the allocation of points within the 10 or the 20. Now, the introduction of pre-qualification criteria goes against what the Act itself says in that number 1, the pre-qualification criteria. There are no points allocated to it as required by the Act. And that pre-qualification criteria is not then looked in within the 10 and the 20 points that are available. It goes beyond, you see. And subcontracting as well is not provided for in terms of the Act. Now that as well is, the minister is said to have acted beyond his powers. Now, currently, as SITA, for example, we have been exempted from the Act. What that then means is there's no limitation in terms of how we advance what we are required to advance in terms of 217.2. Why? Because the framework listed under 217.3, we are exempted from. So we are free to do whatever we can to then advance transformation, preference, and so on. So that is why we can then even put in subcontracting, because we are not limited by any other law, because we are exempted from the law which restricts us, which is the triple PFA. You understand? And we can put in whatever you need to ensure that to comply with 217.2, which does not offer any restrictions. It just says, here's a blank check, transform.
So advocate and to our colleagues here, the Advocate is correct, and we must never forget that there's something, as our chairperson said, spoke about the procurement bill. For those that are still struggling, I think the advocate is here. We can see how we help, that you are exempted from the Act. The Act, when it was promulgated, never applied to Schedule 2 companies. So Schedule 2 companies have always been sitting outside triple PFAs. Only in 2010, and you'll recall when SUF, we wrote to the minister, we asked for an exemption, which we received, but unfortunately it was limited for 12 months. So after 12 months, the minister had left. Now there's new discussion. He said, you shall comply. So there was not even a discussion after 12 months. But the Act itself is not applying, it's not applicable to Schedule 2 companies. So that is why I was saying, advocate, that why are they then going back to be exempted from something that they never applied initially from them, right? It's only in 2010 when the state organs were then brought. Of course, SITA does. SITA, you must ask for an exemption. But the point is really what advocates said is that to do ask, it is a right thing to do, but it's not a legal thing to do if you're a Schedule 2. But it is indeed a right thing to do, to go back to National Treasury and ask to be exempted, even though, because you cannot be asked to be exempted from the regulations. You must request to be exempted from the Act, even though it did not apply from you. It's just sometimes even the Bible says not all lawful things are good, and not all good things are lawful. So it is a good thing to do. It might not be a lawful thing to do, as the advocate said, and the chairperson. It does protect you from all these questions that will be coming at the back end from the AG, and also from your own accounting authority. So do ask for a deviation. But if you create new or new policies, please align yourself to the codes of good practice. At least when you are challenged in terms of the definitions, you have a legal instrument that protects you. Remember, the codes, when the amended codes do give direction as well in terms of awarding of contracts, in terms of sourcing as well. So there is a guide there for you. So I'm looking forward to give comments to the policies of SITA advocate, but to also help our colleagues to make sure that at least they create a very solid foundation for their frameworks.
It is a testing time, but I think it's also an interesting time for SCM. If we go all the way back to COVID, for SCM, many people, including the Harvard Review, for instance, there was an article that said COVID-19 has been a wake-up call for procurement and supply chain, because now more than ever, we need to now come to the fore, decide, and co-create these solutions. So I hear the nightmare, but I also want to say, if we were to perhaps change our perspective to saying it is an opportunity to rewrite, it is an opportunity to influence, and hence when there are public comments, when there are these such forums, it's important that we contribute